Okay, so looks like where we're headed is we will do employment law this week and next week, and then when y'all come back from Thanksgiving, then we'll just have the final. So I guess I should say a couple words about that. Your final is comprehensive because it's required to be by the school. Um, it is just like your quizzes, so you'll do it at home on your own schedule. You do not have to come into class to take your final. It's open book, open note, just like the quizzes are. Shouldn't be anything. I mean, it won't be anything new, and it's not designed to be super uh, tricky or difficult. It's just to make sure that it's really just to go over a lot of the main concepts that we talked about this year. So when you're reviewing, I will post to Cougar View a study guide, and it'll tell you kind of like what topics are on it. Like it might say negligence, or it might say, I don't know, a certain part of employment discrimination. But if it's not on the study guide, then it's not on the final. So I'm not giving you the exact questions, but I am directing you where to look. Um, I think it's just I'll verify this and tell y'all next week, but I think it's just over lecture and notes. I do not think it's over cases or any of your extra reading. I think it's just straight up lecture and basic legal principles. But I'll verify that again. Again, open note, open note. This is all we have, right? Open outline. Anything I've given you, you can use. Obviously, no internet or outside sources, but and you can do it at your convenience. It's not a really long, involved exam at all. So that's where we're headed. We're going to do employment law for the last 3 or 4 sessions that we have. Um, I want to, this goes out to my online people too. If anybody would be willing to volunteer, what I want to do, what I'm thinking about doing is getting like maybe a group of 5 or 6 students, although if I ended up with more than that, that'd be fine. Less than that is fine. To spend maybe an hour on Zoom with me one day, just talking about ways that we could improve the class, maybe ways we could design or things we might could do differently. If you would be interested in doing that, just shoot me a text or email, and I'd appreciate that. It won't take a lot of your time. Here's why I'm bringing that up. I've normally been of the opinion that once something is due and it's past the due date, that's just it. We're not going to give extra chances for a couple of reasons. One is because um, it is a hassle for me to have to be going back in and opening up quizzes and assignments here and there. And it's not that I really mind doing that. It's just that if I did that, I feel like that would condition y'all to know that you could just miss stuff and then just ask me to reopen it, and I would. And I feel like that would not promote the right goals. I don't know. But in opening up all of your quizzes and assignments last week for you to retake them if you wanted to, or make up ones you missed, it occurred to me that that's not really such a bad thing for my goals for this class if you're going to have to spend more time in the subject matter, right? You're going to learn more if you redo it than if you didn't, I think, because then you're going to have to go back and review and think about the material again. And my goal is not so much, I mean, I want everybody to pass and I want you to make the grade that you want to make, but my goal is mainly that you just get something out of this class. that you learn something. So if there's a way, if you guys know of ways or think of ways that other teachers have done it, you guys can share with me ways that you think are effective at getting you to learn the material or actually engage with the material, but also in a way that makes sense for you. I'm all ears for that. My main goal, like I said, is for y'all to learn something. So if you have things that you can help me learn or understand about the best way to deliver that and meet my goal, then I'd appreciate knowing that. So that's a long way of just saying I'm always open for ideas. So if you're interested in maybe spending an hour with me on Zoom talking about ways to make the class better, just shoot me a text. Let's see. Nothing else? All right, if there's nothing else, then we will jump right into employment law. So I want to start out with a very broad principle of employment law, a couple of them. The first is that employment law as a whole is a creature of federal law and state law. So there are federal laws that govern employment that apply to everybody. But each state may have additional employment laws that would apply to folks who are residents in that state, who are doing business in that state, whose business is headquartered in that state. So it's a little bit of a patchwork between state law and federal law when it comes to the broader employment law context. And we're going to look not so much at state laws in this class as we are going to look at some of the major federal laws that govern employment law, like discrimination laws and some basic wage and hour laws and things like that. The second kind of big principle is that the default position in American employment law is called at-will employment. I do want you to know that, at-will employment. And that means that an employer can take an adverse employment action against an employee. By that I mean not hiring them, not promoting them, firing them, be about the most adverse employment action that there is. They can do that for any reason at all. Good, bad, indifferent. Now, as with most things in this class, I'm going to tell you the general principle, and then we're going to start carving out the exceptions to it. But the general principle is that at-will employment means that the employee serves at the will of the employer. If I walk into my office this morning after class and tell my assistant, I only have one employee, tell my assistant that she has gotten on my last nerve for the last time and she's fired, I can do that. She's an at-will employee. So how do we carve out some exceptions to that? One of the exceptions is employees that have a contract. So if you actually entered into a written employment contract, then your contract will govern the terms upon which you could be fired. Lots of times they'll say misconduct, if you break the law, poor performance. It'll spell out the reasons. If my assistant had an employment contract that spelled out all the reasons that she could be fired, and one of them is not getting on my nerves, then she could not be fired for getting on my nerves. Her employment contract would control, and it would depend on what her contract said. Who's the contract between? The employer and the employee. They can negotiate that themselves. So there's no standard employment contract necessarily. So that is an exception to the at-will doctrine. I have a contract to teach at CSU, and I've never read through it to find out what they could fire me for, but I do know that if they fire me, it's got to be for something that's covered by my employment contract. Probably couldn't be for me getting on the dean's nerves or something like that, but you never know. Another exception to the at-will doctrine is if there is a law that prohibits certain reasons for termination. And we have a lot of those. So we're not getting into these today necessarily, but we have laws in this country, federal laws in this country, that prohibit firing somebody based on disability, based on race, color, national origin, religion, age. I'm leaving some out. We're going to get around to all of them eventually. Incidentally, what do y'all think does anybody know what the cutoff age is for being considered under the age discrimination? 16? Well, yes, Steve, in a way. We do discriminate against people under 16 because you got to be 16 to work in some jobs. So let me ask a better question. What is the age, the cutoff age, where you become protected from being fired for being too old? Close, but no. Who said 50? LaPortia? All right, good. I mean, LaMiracle? LaFavor? I'm just butchering your name this morning. 53, somebody said? Is lower. Higher than 35. 40. Yep. It's 40. So, anyway, I don't know how I got off on that. So those are exceptions to the at-will doctrine, would be if there's a statute that prohibits taking action for a certain reason. And like I said, there are plenty of those. Is there anybody in here who is an at-will employee right now? Nope. Everybody has you are? You have an employment contract? So you would be an at-will employee. Steve, you work for family business, but no contract? Really don't have a job. You're probably at will. You're probably at will. All right. Some states also have laws against what they call wrongful discharge. I'm not getting too much into that because every state's law might be different. But the general flavor of a wrongful discharge state law is that a person couldn't be fired for an illegitimate reason. Poor performance is always going to be a legitimate reason. Being late, habitually late, is always going to be a legitimate reason. Committing crimes is almost always going to be a legitimate reason. So even though we start off with the general principle that everybody is at will if you don't have an employment contract, we limit that in some pretty significant ways. Federal laws, well, and state laws cover minimum wage. So let's get into wages and hours for a second. Who knows what the federal minimum wage is? $7.25. Do y'all know how long it's been since the federal minimum wage was increased? 2009 was the last time it was bumped up. That's crazy to me that we can go 50. We adjust so many things for the cost of living and inflation, but we haven't adjusted minimum wage in 15 years, at least on the federal level. So what have some states done in response to that? They have written their own minimum wage laws And so long as their state minimum wage is higher than the federal minimum wage, they can do that. You can't go lower than the federal law. That's our floor, but you can go higher. So I think I looked this morning, there were 34 states whose minimum wage is above 7.25. The highest was like, I forgot the highest. DC maybe? Somewhere it was, some state is $17. So if you operate in that state, you'd be subject to the state's minimum wage. And that is a lot higher than the federal minimum wage. In looking at which states had done it, Georgia does not have a minimum wage that's higher than the federal minimum wage. Georgia's minimum wage is actually lower than the federal minimum wage. And so therefore the federal minimum wage applies. I guess Georgia's just always said we're just going to go by what the federal government says and not necessarily worry about it. But 7.25 feels criminally low to me as someone who has worked minimum wage jobs before. I don't think it's gone up much since I was in college when I had my last one. I wish I could remember what it was. Child labor is what Steve was getting at a minute ago. Federal laws govern child labor say that you can't, if you're under 14, you can only work in certain limited occupations. If you're 16, you cannot work full-time except for under a parent or certain circumstances. And if you're under 18, you can't work in hazardous jobs or jobs that are detrimental to your health and well-being. I'm not going to test you on the intricacies of child labor laws, except for I just want you to know that federal law does govern minimum ages at which a person can work.
How long have those laws been?
I would think, I don't know exactly how long they've been around, but I would think it'd be interesting to track how those evolved over time, because the beginning of our country, a lot of people use child labor, especially in families and farms and that kind of thing. And so I would be interesting to see how that evolved over time.
My granddad used to get a trailer on the back of his truck. He had to feed it and ride around town, and the kids would be so excited to go. And when they didn't go, they'd be mad.
They were dying to work, huh? I grew up in South Georgia in a small town, and our county had a pretty big grew tobacco. And every summer we would crop tobacco, and they would drive the truck around in the morning, pick all the boys up, and we'd hop in the back of the truck and go out to the tobacco fields. And one year I remember I can't remember why, that the crop was not finished by the time school started. So they backed up the start of school because so many students were picking tobacco. It makes it sound like I grew up in the 1800s, but I really didn't. I was in high school in the 80s. That's depressing. Let's move on. Overtime. Here's how overtime works. I do want y'all to understand this. You work over 40 hours in the week, and you're an hourly employee. Overtime does not apply to salaried employees. You work over 40 hours in a week, then for every hour you work over and above 40, you get paid time and a half. So to make this an easy illustration, if I'm an hourly employee and I make $10 an hour, then I'll make the $10 per hour up to 40. Anything over 40, I'll make $15 per hour. That's my time plus 1/2. Okay, but again, that only applies to hourly employees. If you're salaried, you're exempt from overtime, meaning your employer doesn't have to pay you overtime if you work more than 40 hours. So here's one thing that I really want y'all to pay attention to, both as potential employees and as potential employers. It is crucial that the employer classify the employees correctly. It's crucial if you're an employee that you're classified correctly. Why? If you're classified incorrectly and you should be eligible for overtime, but you're not getting it, then you're leaving a lot of money on the table. Your employer is not treating you legally. If you're an employer, you want to make sure everybody's classified right because you don't want to get sued for back wages. But here's the rub on that. Employers have an incentive to classify people as exempt from overtime, right? You're an employer, you would much rather not have to worry about overtime because that costs you. If you're an employee, depending on what your salary is, you might be incentivized to be hourly. I don't know. That could go either way. But you need to make sure that you're classified correctly. The law does spell out in great detail how you get classified. And for our purposes, I just want you to know that generally speaking, people that are exempt from overtime are in managerial type jobs where they exercise some discretion, some independent judgment, that kind of thing. But the misclassification of exempt versus non-exempt employees does go on. And sometimes it happens not in any bad motive. It's just that maybe somebody got hired into a salaried job, but it turns out that it's really more like a non-exempt job, and that's how it should have been classified. It's not always evil motives of employers, but it is important for you to pay attention to that. Family and medical leave. This is important too. So this is an area that, let's talk about what it is first. Family and medical leave was brought into law in 1993. So before 1993, there was not any federal guarantee that you could take time off of your job and still be guaranteed a job when you got back for certain reasons. So prior to 1993, if I went to CSU and said, I need to, I have cancer and I need to do chemotherapy and I'm going to have to go to Texas to do it, and I'm going to need to be out for 10 weeks, they could fire me. They're not guaranteed to give that to me. They could say, you can either show up to teach or we'll find somebody else. That was their prerogative. The Family and Medical Leave Act of 1993 says that in this country, employees are guaranteed up to 12 weeks per year for certain qualifying events. And your outline lists those. So it's to care for new children. That really guarantees maternity, but also paternity leave. To care for an adopted or foster child within 1 year of the placement. To care for a seriously ill spouse, child, or parent. To care for themselves if a serious health condition prevents performing essential job functions. And then to deal with non-medical emergencies that arise out of the fact that there's somebody in the family who's on active duty. So maybe my son gets deployed to a war zone and he doesn't have anybody to keep his daughter, and I need to do that. That would qualify under I could take family and medical leave to care for his child. Here's the rub, though. I don't know if I call it the rub, but here's the reality of the way it works in America. You are guaranteed 12 weeks off, but you are not guaranteed to be paid for the time you're gone. American law does not guarantee paid medical leave. Your employer might decide to do that for you, but it's up to the employer. So what are you guaranteed then? You're guaranteed that you can return to the same job that you held before your leave or a substantially similar job. So you're not necessarily guaranteed your exact same job back. You're guaranteed employment in either your same role or a substantially similar role. Now, let's say that I take the rest of the semester off for medical leave. And I come back from leave spring semester, and they have put me teaching so my contract is to teach 4 classes a semester. Let's say that I'm teaching 2 online in the spring and 2 at night, and I haven't taught at night in 15 years. Would that be a substantially similar position? Probably. I mean, we could argue about it, though. We certainly could argue about it. If they put me teaching, this is made up because I'm not qualified to teach another class. But let's say that they brought me back in the spring and I had to teach business ethics instead of business law. Substantially similar? I mean, probably. What if the business ethics position paid 10% less than the business law position? Is that substantially similar? I say hell no. Right? I ain't taking a 10% pay cut. But it might be relative. And this is obviously a joke. If my salary was $2 million a semester for business law and they brought me back at $1.8 million for business ethics, it might be substantially similar. If my salary is $40,000 a semester and now they want to bring me back at $30,000 a semester, then that's a different story. So substantially similar. If I disagree with CSU about what is substantially similar, who would make the decision in our dispute? Who would decide ultimately if that position was substantially similar? The judge or the jury? The judge or the jury would. So your discussion question for this week and next week involves the way that other countries handle medical leave. I don't know what the percentage is. I don't even know if it's fair to say most countries, but I think it's probably close to that. America having unpaid medical leave is in the minority. Most countries, most developed countries, have their own law that mandates paid medical leave. Meaning if I was in one of those countries and I needed to take leave for chemotherapy, I would be guaranteed to still get paid while I was out. So your discussion question for this week talks about some of the differences in what other countries do. I don't want to get too deep into that today because I want us to discuss that some next week when we have our discussion day. When we talk about the cases and stuff for employment law, I want to talk about the way that other countries do it. My international students, I would like for y'all to come to class knowing how your home country handles medical leave. How much do you get and is it paid or not? You can find it out easy. It won't be hard to Google. But I'd like to compare and contrast that, maybe have a little policy discussion. A couple other fine points about family and medical leave. Even though it's unpaid, the employer is still required to keep the health insurance in place. So you do keep your health. You might not be getting paid, but you will still have health insurance. You also have to be at your job for a year before you're eligible. So you can't get a job and then immediately go on medical leave. That would, I guess, prevents people from getting a job just to secure health insurance and then going out on leave. Health, safety, and income security. So we have a lot of federal and state laws that apply to this. Occupational Safety and Health Act. Remember way back at the beginning of the semester, we talked about the sources of law, and one of them was administrative law. Those are laws or rules that are created by administrative agencies that carry out government functions. One of the administrative agencies we talked about, and I think I gave you an example of some regulations for OSHA, was the Occupational Safety and Health Administration. Remember, we talked about how tall your ladders had to be, how much space there has to be between the rungs on your ladder, how much load bearing each step of the ladder has to be. Very, very, very detailed rules about workplace safety. The Occupational Safety and Health Act is the federal law that puts all this in place. And basically it says workplaces need to be safe, right? They don't write into the law how. They leave that up to the administrative agency to make all the rules to say how. But they just mandate that the workplace has to be safe. Remind me, is there anybody in here who has dealt with OSHA in your job? You have? Where do you see it? You see a poster in the break room, probably. That's federal law. How does it come into play in your job? She works at a warehouse, so it governs almost everything y'all do. What's the most ridiculous OSHA regulation that you have to worry about? If one comes to mind. Harnesses on forklifts. What about hard hats? You don't have to wear a hard hat in the warehouse? That surprises me. Mm-hmm. So lots having to do with your safety equipment protocol. Have you ever been there on the job when OSHA has come in to do an inspection or an audit or anything? If anybody who's covered by OSHA, if you have an employee who dies on the job or you have like 5 employees be hospitalized at a time, you got to report that to the government, and that triggers an automatic inspection. So that is OSHA. Workers' compensation laws are on a state-by-state basis. But the theory and the idea behind workers' comp laws are that you're hurt on the job, and it's an accident. It wasn't intentional. Then you are eligible to be paid workers' compensation benefits directly from the state. No questions asked. In return for that, you give up your right to sue the employer for negligence or any other tort theory that you might have. Okay? So there are benefits and drawbacks to it. Obviously, if I am walking into class and I trip and fall down the stairs and suffer a concussion and I don't know, I've got to I got to have surgery. Workers' compensation will pay for that. I just apply for it, and the state of Georgia pays my costs. I can't sue CSU for it, though. That's my trade-off. Generally speaking, it's probably a pretty good thing for employees, I would say. It takes away the incentive for an employer to dispute injuries on the job or not compensate people for injuries on the job. sort of, Ms. Marshall's saying no. But you could also argue that it also incentivizes employers to maybe not be as careful as they would be if they were worried about getting sued by their employees. Go ahead. So that's the trade-off. Yeah, if she's saying, what if the injury was so severe that the employer was negligent and somebody lost a leg, then you're still going to be compensated for your bills and stuff, but you might not be eligible to recover some of the damages that you would under a tort lawsuit. So if you're seriously injured, you probably would rather sue the employer than do workers' comp. Now, don't misunderstand. You can still sue your employer. You just can't get workers' comp and sue your employer. You can't double dip. So if your employer does something that's grossly negligent with the forklift, and that results in an injury to the worker, they can choose whether they want to sue in tort law or take workers' comp. So it doesn't absolve the employer completely of any responsibility for safety. But that is how that works. We also pay by federal law in this country a certain amount of your paycheck goes to things like Medicare, Social Security, unemployment insurance and taxes, things like that. You see that line on your paycheck and you're like, what is all that for? Where's it going? Most of it's going to government programs that are supposed to benefit the workers. That's all by federal law. We're not getting deep into that for testing purposes on what comes out of your paycheck. But I do want you to understand when you look at that line that that's what that's for. Employers pay insurance into the unemployment insurance fund for each state. Like I have to do this for my employee, everybody that CSU does it for me, so that if I am fired, if an employee loses their job through no fault of their own, like a layoff, or because they're getting on their boss's nerves, they can apply for and get state unemployment benefits, which is basically a certain payment per week for a certain number of weeks. It's going to vary by state. But employers contribute into the state unemployment insurance fund, and that's the money in the pool of money they use to pay people who apply for unemployment benefits. You have health insurance through your job, and you lose your job, whether it's through your fault or not. You are guaranteed the ability to continue being covered by that health insurance for 18 months, so long as you pay for it. And that protects a worker from losing their job and their insurance at the same time. Most of the time, folks get a new job and they have new insurance with their new job, or for whatever reason, it's generally more expensive to continue paying your own insurance with your old job than maybe even to go out in the marketplace and get your own policy. I'm not sure. But most of the good health insurance that employers pay for, they're contributing some of the cost and the employees contributing some. You lose your job and you need to do COBRA, which is the continuation of benefits, and you the employer paying for all of that's a lot. It can be a lot. You realize how good a benefit it is to have the employer pay for some of your benefits at least.
Have you ever heard of an employer like hiring somebody part-time that was already getting unemployed?
If you're getting unemployment and you get hired, then you're not eligible anymore. Is that your question? Yeah, like you can't draw unemployment and then go get paid and then get employment from your new employer either. It's supposed to cover a gap in between jobs. You know, remember when COVID hit, and the government extended all those deadlines, and I don't remember unemployment is not. I mean, it's not a career plan. It's like 4 weeks. I mean, I don't know exactly. It's 4 weeks, and it's not your same pay you were making at your job. It's a much lower rate. It's better than nothing, obviously. But when COVID hit, and then they extended however long you get employment for much longer periods, because there were people who were stuck without a way to get any income for a long time. All right, we're going to flip over in your outline and look at Section 5, Employment Discrimination. So most of the employment discrimination laws that we talk about in this class are federal laws. States do add some here and there, but generally speaking, they don't need to, because the federal laws have pretty much got it covered when it comes to discrimination. So a couple of general points to begin with. One is that there's not one federal law that lists out all the reasons or all the people that can't be discriminated against. It's a patchwork of laws. We have one that we're going to look at called Title VII of the Civil Rights Act of 1964. In short, we just call that Title VII. Title VII is probably one of our biggest anti-discrimination statutes. It's the one that covers race, color, national origin, religion, gender. We have separate laws for things like age discrimination. That's the Age Discrimination in Employment Act. We have a separate law that prohibits discrimination on the basis of disability, the Americans with Disabilities Act, the ADA. And so this patchwork of laws creates what I want you to understand or take away is that the anti-discrimination laws create protected classes. If you're a member of a protected class, then you're protected from being discriminated against in employment. And we're going to talk about all the different ways that a person could be discriminated against in employment. Protected classes: race, gender, sex, national origin. That doesn't mean you have to be from a foreign country. Your ancestors could have been immigrants, but the employee is an American citizen, was born in America. That doesn't mean they're not protected. They're still protected from discrimination based on their origin. Did I say religion? Age, disability, religion. One of the cases that you're going to read for next week involved a change in the law in how we interpret the word sex discrimination under Title VII. So way back to the beginning of the semester when we talked about sources of law and how we have statutes that are written by legislative bodies, but then we have courts that interpret those statutes and write written opinions. So Title VII, the statute just says that an employer can't discriminate on the basis of sex. It doesn't define sex. But over time, courts have interpreted that word to mean we can't fire somebody because they're female, or because they're male, or because they can get pregnant. But the courts did not interpret the word sex as covering sexual orientation. So when cases came before courts, if somebody said, I'm being discriminated against on the basis of my sexuality, the court said, we don't read the statute to include sexuality. The word sex just means basically gender. There was a case in Georgia it's within the last 10 years, where a state employee believed that he was fired for his sexuality, and he sued, and it worked its way up the court system and eventually got to the Supreme Court of the United States. The Supreme Court of the United States said, yeah, all our precedent, all our previous decisions have interpreted this statute as not covering sexuality. But we're going to overturn that. We are now going to read this law that says a person may not be discriminated on the basis of sex as including their orientation. So prior to that case, an employer could fire an employee for being homosexual. After that case, that became illegal. That is an example of what we talked about earlier in the semester about how the law evolves and how courts interpret statutes over time. Now, you'll read in that case, we're not going to debate whether the law should or shouldn't cover that. I'm not interested in that part of the debate. I'm interested in you understanding and seeing how courts change law and rationalize that. And one of the arguments that the dissent makes in that case is, who wrote the law? Congress wrote the law. If Congress wanted to include that in the law, all they have to do is what? Amend the law. Congress can do that. So again, I am not advocating that the decision was wrong or right one way or another. I just want you to appreciate the role of courts versus the role of legislature. Is that there are some that say courts should stay out of the business of legislating. That's why we have a legislature. That's their job, is to write the law. If you don't like it, or if they need to include something, they can change the law. But courts do have the ability to do that as well. And sometimes it takes a court to do it if the legislature isn't going to act in a certain manner. Anyway, that's neither here nor there. So that's a general sort of principle of employment law. Looking at protected classes of people. What does that protect me from? It protects me from an adverse employment decision. Hiring, firing, promotion, demotion. It protects me from a work environment that's hostile to my protected class characteristics. It protects me from being retaliated against if I make a complaint that I've been treated wrongly based on my status as part of a protected class. Protects me from all those things. When we talk about employment discrimination, here's kind of a trick question. Is there such thing as legal discrimination in employment? Ms. Robinson says yes. How come? Well, are there biases that we don't mind people having when they make employment decisions? Yeah, Ben says yeah. What's an example of one? That's right. We discriminate against convicted sex offenders from teaching in elementary schools. We absolutely discriminate against that. We discriminate against children from being air traffic controllers, or people who have visual impairments from being air traffic controllers. So there is legal discrimination. What we're more concerned with in this class is illegal discrimination. Okay, what would be illegal to discriminate against? It happens in, I'm going to say, 3 ways, broadly speaking. One of the ways that employment discrimination happens is in disparate treatment. All right, I'm going to contrast that with disparate impact. So we have disparate treatment discrimination and disparate impact discrimination. Disparate treatment is I'm discriminating against this certain individual. I didn't hire, CSU didn't hire me because I'm Methodist. It's my protected class as my religion. CSU fired me because I'm old. My protected class is people over 40. That's disparate treatment. They treated me specifically in a discriminatory manner. Disparate impact, on the other hand, means that they didn't discriminate necessarily against me individually, but as the result of a neutral policy, I'm one of the people who was impacted by that in a discriminatory way. That's kind of out there. So let me make it a little more concrete. You all have heard about implicit bias in standardized testing. Like the SAT, for example, discriminates against certain members of. I mean, I don't, not well versed on that. I think minorities are one of the folks that it's been alleged to have discriminated against in the past. The writers of the SAT didn't sit down and say, we're going to make up questions that discriminate against minorities. Okay? There was no intent there. In disparate treatment, there's intent. I intended to discriminate. I intended to make that decision against that individual. In disparate impact, there's no intent. There is just the result of the policy or the procedure is discriminatory. So if I write a test that I don't intend to be discriminatory, but we could go back and look at the statistics and see that minorities score lower on the test than any other group, the impact of that test is that it's discriminating against minorities, whether or not it was intentional. Let's say that I have many jobs have entrance exams. No, can't think of the exact name of it, but you take a test as part of your application. Has anybody ever had to do that? Yeah, that's right. So let's say that I am I think this is a real case. I think Duke Energy or Duke Power, some company in North Carolina had a test. And women did significantly worse than men on the test. If you read through the test, there's nothing that jumps out at you that's obvious that it would discriminate against women. But the impact of it was that it did. That's disparate impact discrimination. Disparate treatment is I treated you differently based on your characteristics as belonging to a protected class. Disparate impact is I didn't intend to discriminate against anybody. I have this neutral, on its face, a facially neutral policy, test, procedure, but the result of it is that there is a discriminatory impact on a certain class. So disparate impact cases are, in and of themselves, more like class action lawsuits where groups of people are suing the employer for the disparate impact. They're larger, more complicated, proven largely statistically, right? The larger the sample size you have, the larger group that's being impacted in a discriminatory way, the stronger the disparate impact looks. If I give a test to 5 potential applicants or potential employees, and 3 of them are women and 2 of them are men, and the 2 women pass the test and the 3 men don't, that's going to be really hard to make out a case of disparate impact based on a sample size of 5 people. Could just be that the 2 women were more qualified. But if I give the test to 50,000 applicants and women score 50% higher than the men in a pool of 50,000 applicants, then statistically speaking, I might have something discriminatory going on. Again, not intentional. There might be something baked in that's resulting in discrimination. All right, another way that a person or employee can be discriminated against is through a hostile work environment. Let's say I work in a area where we have cubicles. There's 50 people in my little area on my floor, and I'm the only Methodist. Everybody else is Catholic, and everywhere I turn, there's Catholic imagery, symbolism. We do Catholic prayers as a group every 10 minutes. We get all the Catholic holidays off, but no Methodist holidays. I'm making up stuff. Okay, that might be a hostile work environment. I didn't lose my job because I'm Methodist. I did not get hired because I'm Methodist. But the atmosphere is oppressive and discriminatory to me. Most of the time we think of hostile work environment as being related to sexual harassment, like men making off-color jokes or talking about men treating the workplace like a locker room, and there are women in the workplace. It could happen the other way around too. So I'm not picking on men. Sexual harassment through hostile work environment. We're going to get into sexual harassment a little bit more Thursday. There's other ways to sexually harass somebody than just hostile work environment. But that's kind of a general flavor of how the discrimination laws are set up. So on Thursday, what I want to do is I want to finish my lecture. So we'll finish up talking about employment discrimination. We may look at some scenarios. And then Tuesday of next week, we'll discuss the cases and the New York Times article on family leave around the world. And then that'll leave us next Thursday to review or do whatever we decide to do. All right, so, I know. Let me tell you one more thing. You do have a quiz this week and next week. So the quiz this week is going to be on the lecture and the outline. The quiz next week is on the cases. Trying to give y'all some extra grade opportunities to make good grades as we wrap this up. Remember that your discussion questions are due by the end of the semester, which is next week. So I want all the discussion questions done by Friday before Thanksgiving. And then if you've answered all those questions, you'll get 100 on the discussion grade. Easy money. All right, see y'all Thursday. Ben, I have a question for you. Actually, I have 2 questions.